In this video, we're going to talk about how to tell if a client is really your client. So the purpose of this training is to give you an understanding of who you really represent and if the buyer is obligated to work only with you. Let's discuss the difference between a customer and a client. See, a customer is a person who's provided services by a real estate professional, but who isn't a client. The actual services you receive from a real estate professional as a customer depends on the arrangement that's established between that client or that customer and the licensee. A customer uses the service of a real estate licensee, but has not signed an agreement with the agent. Now, a client, on the other hand, is a party who has signed an agreement with the agent, and that agreement creates a fiduciary relationship. So we'll talk about what it means to have a fiduciary relationship. But I want you to understand that when you go out and just start showing people homes and talking to them about real estate, asking them questions, you're really starting an implied agency. And you want to be very careful that you don't create an implied agency, because the implied agency is a gray area between having a prospect and actually having a client. And their responsibilities are quite different from a prospect and a client. But you don't want the client to feel that you're really representing them if you don't have that agreement in place. That's where implied agency can get you into trouble. Implied agency means that an agency is created from the conduct of the principal and agent. It is generally inferred by circumstances that imply an intention to create an agency relationship. So you're doing the things that kind of look like you're representing them, but technically you're not, because you don't have those duties and responsibilities that the client deserves. So let's use this case study. Sally's sales agent has been showing homes to a buyer for the past 3 months. She's found properties for the buyer, even found out information, given answers to questions that the buyer has. Sally gets a call from the buyer, and he says he really appreciates what Sally's done for him, but his cousin has a real estate license. And, he decided that he'd write up his offer with that client or that cousin. I'm sure that a lot of you can relate to this case study because it's probably happened to you. You have somebody that just calls you up out of the blue after you've been doing all kinds of work for them, and they're just going to go with another real estate agent. Well, the question is, does Sally's sales agent legally represent the buyer? And is he obligated to continue to work with her only? Let's talk about how a client hires you. So the form that we use in the state of Utah is an exclusive buyer-broker agreement and agency disclosure. Now, notice it says agency disclosure, because this agreement is not just a contractual agreement between the brokerage and the client. It is a disclosure of how the brokerage is going to represent them. So you have to be very clear on what your responsibilities are for that client, and also what their responsibilities are to you in the brokerage. So when you have a buyer-broker agreement signed with a buyer, you now have a fiduciary responsibility to them. So let's talk about what the fiduciary duties are of that relationship. You can use this, the term old car, to kind of remind you of what all is involved with a fiduciary duty. The O stands for obedience. As an agent of your client, you must obey their instructions, barring any illegal, unethical requests or requests that contradict terms of the contract. So if they tell you they want to make an offer for $50,000 less than what the property is listed at, it's your duty to go ahead and put it in writing, whatever they're wanting to offer. Now, you can advise them, but ultimately, if that's what they want to do, it's your responsibility to do that for them. Loyalty is the L. And as the agent for your client, you must be loyal. You have to keep their best interests ahead of any other parties, including yourself. How much commission you might make, particularly in competing offer situations, should not be a consideration, and it really would be disloyal to your client if your money is more important than taking care of them. The D is for disclosure. In a lot of states, the law requires that, well, actually in all states, the law requires that a real estate agent, whether in an agency capacity or not, must disclose material facts to their clients. Material facts are those which, if known by the buyer or seller, might affect the purchase or sale actions. The C stands for confidentiality. So it is your duty to keep everything confidential unless they tell you that they want you to tell the other side something. So you can't disclose anything that you learn about your client. You can't disclose about their business, financial aspects, or personal affairs, or their motivation, whether they are a buyer or a seller. The A stands for accounting. So it's your responsibility to account for all the documents, for the funds in the transaction, and to create accurate reporting of the whereabouts of where the money is and their disposition. It's all part of that responsibility. The R in old car is for reasonable care. So you have to take care of them, in as many ways possible. The words reasonable care are fully defined in court cases by a judge or a jury. And by then it could be too late that your actions are being determined. Did you provide reasonable care for your clients? So you owe them to serve them, take care of them, be responsible for the paperwork, their monies, and not disclose things that they have not told you you could disclose. There are a lot of things that are involved with this fiduciary duty. And if you don't have an agreement with them in writing that they're obligated to you and you're obligated to them, you have nothing to go on if they decide to go off with another agent. Utah law states that you must disclose how you'll be working with somebody and who you represent prior to writing a contract. Now, I see a lot of agents that they get the buyer agency agreement signed at the time that they're getting a contract signed. That is too late. I know technically you could do that at the last minute, but you are not sufficiently giving notification to the person that you're representing as to how you represent them. And it goes back to that idea of there could be implied agency. I will never put anybody in my car or meet with them unless I have gotten an agreement signed with them to let them know how I'm going to represent them and that they're responsible to me. It doesn't make any sense to work with someone, spend hours and hours, days, months, possibly years, working with someone that you're not guaranteed to be paid from. You wouldn't do that when you're listing a house. A lot of agents have no problem with going ahead and doing the exclusive right to sell from the very beginning. That should be the case for every buyer that you work with. Here's another case study. A buyer approaches you and tells you that they've been looking at homes in the area, but they'd like to work with you now. Upon further investigation, you find out that they've been working with another agent and they have a buyer broker agreement signed. So question is, can you start showing them houses and working with them? Absolutely not. They are already under contract for agency with the other company. They could go to the other company and let them know that they don't want to work with them anymore and try and get that canceled, but you can't facilitate that discussion. You just have to tell them, I'm sorry, until you're released from your buyer broker agreement with your previous agent, I can't work with you, and let them do what they're going to do. But don't give them any directions on that. So this goes into the Code of Ethics, Section 16, Article 5. If you want to look at that, really get clear information about that. And the last point is, to me, it's just a big red flag. If somebody is not willing to sign a buyer broker agreement, then you should run far, okay? Because there's something going on. Either they don't want to be connected to you. They want to use you all they can and then do something else. It just doesn't make any sense for them not to want to hire you. An attorney is not going to work with anyone unless they have a contractual agreement with them. Even your doctor makes you sign forms before they even meet with you, before they'll even treat you. Why in the world you as a professional should always have a contractual agreement with everyone that you're working with? Then there's no question, there's no problems in the future. There are times when a client can say, you're just not doing the job right for me. And, you can have a discussion about that and talk to your broker about that and see if the brokerage is willing to release the client from the agreement. But if you're taking care of your clients, you want to make sure you're going to get paid. And this is the way to do that. So you're not dropping the ball and crying when they go off to someone else and buy a house.